Hi there, I'm Elizabeth Ritchie with Rambana and Ritchie Immigration Attorneys. I'm sorry I'm not with you in person today to give this CLE. I'll explain why, but first, thank you, Amanda. Thank you, Ian. Thank you, Johnny, for having me. I appreciate your patience as we went back and forth regarding this recording about immigration and the Administrative Procedures Act. I'm going to go ahead and share my screen so we can get started. Here we go. Okay, so first let me tell you a little bit about myself. I've been practicing immigration law with my husband and law partner, Neil Rambana, who helped with this presentation this morning. We've been doing immigration for about 20 years. I have taught administrative law, legal writing, immigration law at the college level, and right now I'm teaching legal issues at Maclay, which is a good time at the high school. I practice mostly family and business immigration, while Neil does the removal or known as deportation, more commonly, work. So again, I apologize I'm not there, but I'm going to give you my cell phone and my email now, and I'll give it again at the end in case anyone has any questions for either Neil or I that you'd like to follow up on. So my cell is 850-544-9970, and my email is elizabeth@rambana.com, and Neil is neil@rambana.com. So I'm going to get started giving you some basics about immigration. I don't know how much of the immigration field you all are familiar with. So some of the types of cases I'm going to talk about today, I will mention briefly now and give you an explanation of what they are. And that is H-1B. H-1B is a specialty worker visa. It is good for up to 6 years, generally. There are some exceptions to that because immigration is so backlogged. We have a quota system. So generally it's up to 6 years, but you can get extensions, sometimes indefinitely beyond the 6, if you have a green card or a labor certification that was filed by your 5th H-1B anniversary. There are also exceptions for people who received their degrees here in the US, and those were STEM-related degrees. So you may have heard about the H-1B lottery last year, and this year there was an electronic registration system that was new. The reason for this quote lottery is that there are a limited number of visas available every year. And what the electronic registration process was supposed to do was eliminate fraud where you had one employer filing for multiple applications for the same person. Whether that were a true concern or not is another issue. So that window closed this past March, and now only nonprofits that are associated with higher learning or our institutes of research can file H-1s. Everyone else is going to have to do theirs next spring. I'll also briefly talk about the L-1, which is an intra-company transfer, meaning a company abroad is filing for a branch, subsidiary, or affiliate here in the US and transferring an employee from within the company to that branch here. I'll talk about TPS, which has been in the news a lot. TPS stands for Temporary Protective Status, and that is a designation given by the Department of Homeland Security to people from designated countries that are suffering from anything like Hurricane Mitch, which was granted to people from El Salvador because they could not return home safely in the 90s, up to this March when it was granted to people from Venezuela. So TPS is exactly the T, like I said, stands for temporary. It is not permanent residency. It is not a green card. It is not citizenship. It is a temporary status. I'll talk about R1s. That's a religious worker visa. Removal and deportation. So removal is basically the new term for deportation. And in the deportation context, you might hear about voluntary departure, which is a lesser punishment, if you will, than deportation. Someone may leave the US under an order of voluntary departure where they are not, they don't have that deportation on their record and could come back to the US in the future legally. They may have to go through some other processes, but they don't have the deportation on their record. And then I'll probably mention at least once the special immigrant juvenile, an SIJ, which is a young person who basically gets an order of dependency by a family law court that they have been abandoned, they do not have parents, what have you. And then if they get that designation before their 18th birthday, they are allowed to remain legally in the United States. So those are some of the terms that you might not already be familiar with. We'll talk a little bit about how wait times are an issue for the APA, the immigration context, and a couple of cases that came out in the last 2 years that I've been using a lot. We'll talk about form, venue, statute of limitations, who has jurisdiction, causes of action, limits on judicial review, who can be a party to an APA suit, about the standard of review, talk about discovery, and a little bit at the end about attorney's fees. Okay, so this case, Inspection Expert Corporation versus Cuccinelli. It came out in, the holding was last March, and it's something that I've been using now in my H-1Bs, because what was happening, especially in the last 4 years, was that immigration, or USCIS, was denying cases for reasons that they previously had not done. And in this particular case, the employer accepted a person with an engineering degree, and immigration held in its denial of the H-1B visa that an engineering degree was not appropriate and denied the case. And then the employer sued and they won, because that holding was arbitrary and capricious, as we'll learn under the APA is a no-no. Okay, so what is the APA? It's a federal statute that regulates federal agency action in a number of ways. So one agency that I deal with mostly is USCIS, United States Citizenship and Immigration Services. Our local office is in Jacksonville. There's another local office in Montgomery, Alabama. ICE, which is Immigration and Customs Enforcement, is here in Tallahassee, and the immigration court for our non-detained docket, so you know, is in Orlando. So what I'm going to talk about today are the provisions of the APA that would allow someone to sue immigration, or USCIS, in federal district court for unlawful action or inaction. And the suit must be for non-monetary relief, like an injunction. The APA states that a person who is suffering a legal wrong because of agency action, or who's adversely affected by agency action within the meaning of the relevant statute, is entitled to judicial review. The APA creates a cause of action. It provides an individual with a basis to sue a federal agency where Congress has not specifically provided for such a basis elsewhere in the law. The APA also provides a waiver of sovereign immunity that allows a person to sue the federal government over unlawful agency action, as I said, for non-monetary damages. It is not a jurisdictional statute. It does not give the court the initial authority to hear a case. An APA case's jurisdiction is based on 28 USC section 1331. What types of immigration-related claims can be brought under the APA? Well, the APA has been used as a remedy for unlawful action against immigration agencies in several ways. And they include these examples: where a court reversed the denial of an R1, a religious worker visa, where it was based on the improper application of a regulation; where a court granted preliminary injunction, where there was a reasonable question whether directives from the Executive Office of Immigration Review violated the APA; where the court reversed the denial by USCIS of specific consent to pursue a special immigrant juvenile this in state court; or where the court reversed USCIS denial of an H-1B visa, where the AAO, that's the Administrative Appeals Office, made findings that there was no basis on the evidence in record, and that the agency actually ignored evidence that was in the record. I want to talk about the fact that the APA does not include cases of removal or deportation. So the APA is inapplicable there. There's a case, Hamdi versus Napolitano, where it was decided that the APA does not apply to a claim by a severely disabled US citizen child that removal of his undocumented mother would violate his constitutional and international law rights because the APA does not provide subject matter jurisdiction for review of the mother's removal order. Also applies to other government materials. So unlike regulations, USCIS now superseded Adjudicator's Field Manual and Customs Inspector's Field Manual and the EOIR's Operating Policy and Procedure Memoranda, as well as ICE's field directives, may fall within 5 USC 553 as an exception for internal directives and may not require compliance with the APA. I'm going to talk about one other case you've probably heard in the news quite a bit in the last year, which is DACA, Deferred Action for Childhood Arrivals. So DACA was an executive order that came out in 2012, which allowed people who came to the United States either undocumented or documented and became undocumented to receive basically a temporary reprieve from deportation. It, like TPS, does not give anything permanent. It's not a green card, permanent residency. It's not citizenship. It allows for a work authorization. So the specific DACA requirements are as follows. The young person had to have come to the United States before the age of 16, so 15 or under, have continuously resided in the US since June 15th of 2007, are in school or have graduated from school. And there's a few nuances there. You can be in high school, you can be a high school graduate, you can be getting a GED, you can have a GED or be attending what's called a qualifying English program. Not have been convicted of a felony, significant misdemeanor offense, multiple misdemeanors, or otherwise pose a threat to national security. You could also have served in our military, which does happen, and I'll talk about that separately later. And we're under 31 the day of the announcement in 2012. If you met those criteria, you can file for an initial DACA or renew your DACA. And immigration has various fees for those, which include fingerprinting, and are right now at $495. Despite some efforts last year to change the filing fees, that is still the filing fee. So what happened was the Department of Homeland Security tried to effectively block DACA, as you may have heard, and regents of the University of California sued, and it went to the Supreme Court. And the issue was not whether DHS had the authority to rescind DACA, but it was whether the APA was followed. So the Supreme Court held that Homeland Security's decision to rescind DACA was arbitrary and capricious, and thus an APA violation due to the agency's failure to perform a sufficiently reasoned analysis in making its decision to rescind DACA. So DHS's decision was set aside, and now DACA remains in effect. And I suppose it could be rescinded if the APA were followed, but that is highly unlikely under this administration. Because DACA was an executive order, I want to talk about executive orders in light of the APA. So a president's executive order can be challenged under the APA if it runs afoul of the Constitution, contravenes direct statutory prohibitions and is therefore ultra vires, is in conflict with other statutory provisions, or results in action by a lower level executive figure in excess of his or her authority to enforce the executive order. On the other hand, the APA can be used to enforce executive orders against an agency's failure to act where the executive order has the force of law. So I thought you would find it interesting that we've got some APA issues as recently as this year with DACA. So where can an APA suit be filed? An APA suit is going to be filed in federal district court. The venue is determined by 28 USC 1391E, which states that a suit against the federal government or a federal official acting in his or her official capacity can be brought in any judicial district where the defendant resides, substantial part of the events or omissions giving rise to the claim occurred, or the plaintiff resides if no real property is involved in the action. An APA suit is a civil action, and therefore the federal rules of civil procedure and the district court's local rules apply. So here's a link to our local rules, which would dictate how such a case would go. Statute of limitations. Let's talk about that. All courts have ruled on the issue and have applied the general 6-year statute of limitations for suits against the US in APA actions. However, there are no cases specifically addressing this issue in the immigration court. There are 2 immigration exceptions to the 6-year rule, and they are: 1, the reopening doctrine, where an agency issues a new promulgation of the regulation and creates the opportunity for renewed comment and objection because the agency may have reconsidered the rule and decided to keep it in effect. Or 2, the rule is challenged, quote, as applied, and the challenge to the enforcement action is brought within 6 years of enforcement. Let's go to jurisdiction. What is the jurisdictional basis for an APA suit? The federal question statute, 28 USC 1331, is the basis for jurisdiction in an APA suit for review of agency action. The APA, 5 USC 702, can also be listed in the jurisdictional section of a complaint. While the APA does not provide an independent grant of jurisdiction, as I said, to the court, it does not waive sovereign immunity in suits against the government for injunctive relief. Such a waiver is necessary for the court to exercise its jurisdiction. Let's see. Because an APA action is against the federal government, does the APA include a waiver of sovereign immunity? We just went over that. Are there other jurisdictional grounds? Let me back up in a moment and say that the US, as we know, is immune from suit and can only be sued if there's a specific waiver of immunity. And the APA includes a statutory waiver, which states an action in a court of the United States seeking relief other than monetary damages and stating a claim that an agency like USCIS acted or failed to act shall not be dismissed, nor relief therein denied on the ground that it is against the United States or that the United States is an indispensable party. The United States may be named as a defendant in any such action, and a judgment or decree may be entered against the United States. So the waiver of sovereign immunity found in the APA applies to suits that seek relief other than for monetary damages. And this usually includes that injunctive and declaratory relief like we saw in inspection expert. The APA's waiver of sovereign immunity applies to agency action or inaction, including agency inaction by an agency officer or employee. And several courts have held that this waiver applies in suits against unlawful agency action, even if the suit is not brought under the APA. Are there any other jurisdictional grounds that can or must be included in an APA complaint? Well, whether there are other jurisdictional grounds to include in the complaint are going to depend on the nature of the lawsuit and the claims that are raised. So it's best to include all the potential grounds for jurisdiction. For example, if you have a claim for mandamus, which we often see in the naturalization context, you'll want to include the federal mandamus statute, 28 USC 1361. Let's talk about causes of action. What does it mean for the APA to provide a cause of action? Whether there are other, the court may have made clear that while the APA is not a basis for federal jurisdiction, it does provide this cause of action for parties who've been adversely affected by an agency action. The case there is Bennett versus Spear, which states that 5 USC 704 provides a cause of action for all final agency action for which there is no other adequate remedy in court. I'll talk more about that in a moment. As a cause of action, the APA provides an individual with a basis to sue a federal agency for unlawful agency action where Congress, as I said, has not specifically provided for such a basis anywhere else. It also permits courts to provide redress for a particular kind of claim. What kind of agency action now is reviewable under the APA? So the APA states that a person who's suffering a legal wrong can pursue a suit, including, for example, an agency action for the denial of a visa petition or an application for adjustment. So the visas, like I said at the beginning, might be an H1 specialty worker, an R1 religious worker, or this adjustment of status, which is the green card. And I should mention the green card is a slang expression for lawful permanent residency. And we see the adjustment context is usually where a spouse, a US citizen spouse, is filing for their foreign spouse. So it can also include the agency's failure to adjudicate an adjustment of status case or a green card for a spouse. Some of the limitations, as I mentioned, there's no judicial review where another statute precludes review. The APA does not apply to the extent that another statute precludes it. In all cases, though, it's important to determine that if there is a statutory bar to judicial review, it could impact the APA claim, and if so, exactly what the scope and impact of that bar might be. So something to consider, one of the more significant INA restrictions, and I should mention INA is Immigration and Nationality Act, on judicial review relevant here is the limit on review of an order of removal or deportation to a petition for review in the Court of Appeals. Several courts have held that in addition to barring direct challenges to removal or deportation orders by means other than a petition for review, this section bars district court actions that indirectly challenge removal orders. The distinction between an independent claim and an indirect challenge turns on substance of the relief that the plaintiff is seeking, where a claim challenges, quote, an agency determination that it is inextricably linked to the order of removal, it is prohibited by section 1252A5. There is no review of agency action committed to agency discretion by law. So under 5 USC 701A2, an agency action is reviewable under the APA except where it is committed to agency action, where it is committed to agency discretion by law. The government takes an expansive view of what constitutes agency action committed to agency discretion, and will move forward to dismiss a case on this basis. But fortunately, the courts have taken a limited view of this. So the first step in an analysis under section 701A2 is to look at the statute to see if it sets forth a standard against which to measure agency action. For example, in Spencer Enterprises, the court determined that the statute setting forth eligibility requirements for an employment-based investor visa provided a standard to measure USCIS's decision of whether to approve a preference petition for such a visa. As a result, the court found that there was law to apply and that there could be judicial review under the APA. In contrast, courts have found that agency action is wholly committed to agency discretion in limited circumstances where neither the statute nor the regulations provides any guidelines for the exercise of discretion. Like courts have held that the Board of Immigration Appeals refusal to reopen a case sua sponte is unreviewable on this basis. Similarly, the Fifth Circuit has held that under prior law, the APA did not apply to the review of a grant of pre-hearing voluntary departure because there were no guidelines for the exercise of this discretionary authority set forth in the law. Exhaustion of administrative remedies, one of my favorites. Generally, before seeking federal court review of a decision of an administrative agency, an individual has to exhaust all administrative remedies. If the individual fails to do this, the court may refuse to review the case. The Supreme Court has held that though there are limits on when exhaustion of administrative remedies can be required in a suit under the APA, that's the Darby versus Cisneros case. Under Darby, the court held that in federal court cases brought under the APA, a plaintiff can only be required to exhaust administrative remedies that are mandated by either statute or regulation. So for a cause to be exempt under the exhaustion requirement per Darby, the following criteria has to be met. The federal suit is brought pursuant to the APA. There's no statute that mandates an administrative appeal. Either there is no regulation that mandates an administrative appeal, or if there is a regulation that mandates an administrative appeal, it does not apply to stay the administrative decision pending the administrative appeal, and the adverse agency decision being challenged is final for purposes of the APA. The Darby rule has been applied in immigration cases brought under the APA, with the courts concluding that no exhaustion of administrative remedies was required. Final agency action. Section 704 of the APA says that final administrative action for which there's no other adequate remedy in court is subject to review under the APA. This finality requirement is somewhat intertwined with exhaustion, where there are administrative remedies that must be exhausted according to Darby. The finality requirement is also distinct from the exhaustion requirement. Even where exhaustion of administrative remedies is not required under Darby, the APA still requires that the agency decision be, quote, final in order for it to be challenged in federal district court. So this means that the Supreme Court basically held that in general, two conditions have to be satisfied for an action to be considered final. One, that action must mark the consummation of the agency's decision-making process and cannot be of a mere tentative or interlocutory nature. And two, the action must be one by which rights or obligations have been determined or from which legal consequences will flow. Other immigration actions have not been final under the APA. For example, USCIS determination of marriage fraud was not a final action. Rather, it would become final when the visa petition was denied. A couple of other examples include the denial of an I-129 application petitioned by an L-1A, that's that intra-company transfer by USCIS. That did constitute a final agency action, notwithstanding the pendency of a removal proceeding of the beneficiary, because the decision was by a different agency that is housed in a different executive branch department and is vested with jurisdiction over different issues. Likewise, termination of F1 status. I did not mention F1 at the beginning, I apologize. F1 is an academic student visa. So the termination of an F1 status is a final agency decision, and neither in the process of reinstatement nor placing terminated student in removal proceedings renders termination non-final. Another case that I use regularly is the Relix Inc. versus Baran, and Relix is spelled R-E-L-X. Under this case, it was the government's claim that agency action was not final for purposes of summary judgment was rejected because USCIS had reopened an H-1B denial where the petitioner's summary judgment motion was pending, and the court found three reasons for rejecting the argument. One, USCIS failed to follow reopening regulation. The agency failed to give any reason to reopen other than that the response was in light of litigation. And three, they reopened the case and issued an identical request for evidence as they had already issued. So these kinds of cases may also encompass a collateral order. The Board of Immigration Appeals decision to sua sponte reopen a proceeding 3 years after a petitioner was granted asylum is reviewable as final agency action because the collateral order doctrine applies to administrative proceedings and it is a collateral order. On the other hand, the Dhakal versus Sessions case, and that's Dhakal. In Dhakal, a TPS grantee was denied an asylum application and did not have final decision on an, and USCIS did not have final decision on an asylum because it must await the immigration court's decision. And the fact that temporary protective status renders Department of Homeland Security from initiating removal proceedings does not make the denial the affirmative application final. Who has standing other than all the people that we've just talked about? In federal litigation, Article 3 of the Constitution imposes a requirement, of course, that a plaintiff have standing to sue, which generally requires that the plaintiff have suffered a sufficient injury in fact. But the APA imposes some additional standing requirements. Specifically, a person suffering legal wrong because of agency action or adversely affected or aggrieved by agency action within the meaning of a relevant statute is entitled to judicial relief thereof. Per 5 U.S.C. 702, the Supreme Court has interpreted this provision as requiring that a plaintiff not only have an injury, but also demonstrate standing under the APA by showing that interests sought to be protected by the plaintiff are arguably within the zone of interest to be protected or regulated by the statute. The zone of interest test does not require a plaintiff to establish that Congress specifically intended the benefit to the plaintiff. Rather, there's this two-step inquiry. First, the court must determine whether the interest in the statute arguably was intended to protect. And second, the court must determine whether the plaintiff's interests affected by the agency in question are among them. One court has described this test as a fairly weak prudential restraint requiring some non-trivial relation between the interest protected and the statute and the interest in the plaintiff seeks to vindicate. Even so, the quote zone of interest test denies the right of review if the plaintiff's interests are marginally related or inconsistent with the purposes implicit in the statute. So applying this test in the immigration context, many courts have held that a non-citizen beneficiary of a family or employment-based visa petition is within the zone of interest of the statute and thus has standing to sue over the denial or revocation of a visa petition. Let me talk a little bit about those types of cases. You hear people say, get in line all the time. And when people say that, they often don't realize how long the line is. I was on a call with some Senate staffers the other day as part of an advocacy on behalf of the American Immigration Lawyers Association. And one of our members mentioned the statistic that the line can be 70 years long for certain people. So we have a quota system that often acts as a disincentive to legalization because we are limited by what countries can get how many visas. So in the family context, the backlogs we see are from Mexico, Philippines, and India. Those are the three most backlogged. In the employment context, it's India and China are the most backlogged. And when I say backlogged, just this past week, the visa bulletin jumped forward. And let me explain that the visa bulletin is the document that the Department of State publishes that tells you when it's your turn, basically. So you can have an approval, family or an employment-based approval, that's 20 years old, but the approval in and of itself doesn't do anything for you. You also it has to be your turn in the line, this famous line. So for India, the bulletin jumped forward last week, and now it's only an 11-year wait. And this is for people who have a master's degrees and above and are typically physicians. So what happens is, and you'll remember at the beginning, I mentioned that there's usually a 6-year limitation on the H-1B. And the reason we have exceptions to that is because these backlogs are taking so incredibly long, and they're artificial, these backlogs. They certainly don't need to be in place, and they're not by statute imposed. So we have doctors who are here on H-1B visas. They had a green card filed for them by their hospital, which is usually the case, but because of this backlog, they cannot get their green card until it's their turn. And like I said, we're 11 years out right now. So to compound that, a lot of these physicians have spouses who are usually also highly educated, often are physicians as well. But because the H-4 category, which is for spouses of H-1B holders, H-4 does not allow employment. So we have these very highly educated people who are sitting at home and not able to work. So there was an accommodation for that, where if you had a green card application pending, but you couldn't take advantage of it because of that visa bulletin delay, the spouse was allowed to obtain a work authorization, which was really ironic, because now we have the H-4, the spouse of the H-1B, the principal applicant. That H-4 is allowed to work for anyone, but the H-1, usually physician, is only allowed to work for whomever petitioned for them. So there's a lot of inconsistencies, but it's these backlogs that are the real problem, and where immigration gets sued. So I can talk a lot more about that, but I'm going to get back to the APA. Another example we see is where a special immigrant juvenile petition, that's that young person who got a dependency order from the family law court. An SIJ visa also has been found to fall within the zone of interest under that provision of the INA. All right, who can be named as a defendant? The APA provides that the US can be named as a defendant in an APA action. That's per 5 USC 702. It specifies, though, that an action seeking mandatory or injunctive relief shall, quote, specify the federal officer or officers by name or title and their successors in office personally responsible for compliance. So it's best to name as defendants the specific individual within the agency who can carry out any injunction or other mandatory order of the court. Now, we've seen in the last couple of years a high turnover at these agencies, so you certainly can put the person's name, our field office director over in Jacksonville, but it's also appropriate to name the actual title, because that person may not be the one on the other end of it by the time this comes to fruition. Standard of review. What's the scope and standard of review in an APA suit? 5 USC section 706 provides for 2 general types of relief and generally sets forth the scope of review for each. First, the court can compel agency action unlawfully withheld or unreasonably delayed. So it's only really an unreasonable delay if it's unique to that particular case. But now what's happening is everyone is unreasonably delayed, 11 years for a doctor, or what I'm seeing now in the adjustment context, where that spouse is sponsoring, that US citizen spouse is sponsoring his or her husband or wife. It used to be that work authorization card would be granted within 90 days. And now we're seeing that we're not even getting a receipt for 60 days. And then it's going to be about 100 days from then to get that work authorization. So I mentioned disincentives to legalization earlier. We've got the issue where it makes it very difficult for someone who's here legally to support themselves and their family and use their talents, especially if they're highly educated, if they can't do anything for several months or even a year. Along those same lines, I do a lot of national interest waiver work, which is that self-sponsored green card, usually for scientists or inventors. I do some artists as well. Well, they don't have that automatic work authorization the way that a spousal case has. They have to wait for the actual it's called an EAD, employment authorization document, to arrive by mail. And usually we're talking about people who are working on predicting earthquakes or researching the causes of epilepsy, for example. These are people we want working now. But those cases are taking at least a year, especially for China and India. So I don't want to get political, but that's a big issue. Back to the APA question about scope and standard of review. The APA also states that a court can hold unlawful and set aside agency actions, findings, and conclusions that meet one or more of 6 standards. That's under 5 USC 706(2). 4 of these standards apply to all cases without limitation, and thus most would often apply to the type of suit that I'm going to mention. And there are 4: arbitrary and capricious, abuse of discretion, or otherwise not in accordance with the law. Saw that a lot in the last 4 years. Contrary to constitutional right, power, privilege, or immunity. In excess of statutory jurisdiction, authority, or limitations, or short of statutory right, or without observance of procedures required by law. Next, let's talk about discovery. Can discovery be carried out against the government in an APA suit? Yes, sometimes. The general rule in an APA action is that judicial action is limited to the administrative record, and thus no discovery is allowed. There are exceptions to this rule. Moreover, in any case in which there are additional claims besides the APA claim, the court may permit discovery outside of the administrative record with respect to non-APA claims. As a general rule, judicial review under the APA is limited to the administrative record that was before the agency when it made its decision. That's the Overton Park case. The focal point for judicial review in an APA suit should be the administrative record already in existence, not some new record made initially in the reviewing court. Based upon this rule, the government will frequently oppose discovery in an APA action. It's funny because I might get a request for evidence in, for example, an H-1B case or national interest waiver case, and I will answer the issues that came up in that request, but then I'll get a denial saying something that was completely outside of the request for evidence. That is a very common procedure by USCIS. There are some exceptions to this rule. The primary exception is when there is no administrative record for the court to review, or the review may be insufficient with respect to the claims in the suit. Such an incomplete record may, quote, frustrate judicial review, and the court can inquire outside the record when necessary to explain the agency's action, or when the agency has relied on documents not in the record. For example, they use someone's Facebook posts that were not part of the record. I've seen that. I want to go back and mention one thing as far as not in the record, maybe not appropriate at this time. You can call me on my cell. We'll talk about it. Let's talk about attorney's fees. So can you get attorney's fees in an APA case? The answer is yes. The Equal Access to Justice, or EAJA, outlined in 28 USC 2412D and 5 USC 504, does authorize the payment of attorney's fees and costs for successful litigation against the government in federal courts. Excuse me. So it's always a good idea to request attorney's fees. I'm going to talk about a case in a moment. This case here is a great example of it. This is not mine. This excerpt is from an order where a Mavney soldier, his case was denied for years, and he was able to get, or his attorney was able to get, over $13,000 in attorney's fees. I'm sorry, excuse me. So what I'll talk about next is a pro bono case of mine. I do take foreign-born veterans cases at no charge. And even though There's no fee. We do enter into a contract, and I do say in the contract that I'm entitled to EAJA fees. I'm sorry. So this is a great example of that. Again, this is a MAVNI case. This was not my case, but this case here is, I'm sorry. So let me talk about this case briefly. This is actually the reason why I'm not with you live today. I'm in Orlando representing pro bono Paul Canton, who you see pictured here. Mr. Canton was, he's from New Zealand originally, but was not entitled to birthright citizenship. His parents were not New Zealanders. He was raised in Australia, which has a rule, as most countries, including the United States have, that if you serve in a foreign military, your citizenship is renounced or revoked. So Paul came over as an exchange student on a visa as a teenager and worked as a farmhand. And he was recruited by an unscrupulous recruiter who promised him US citizenship upon discharge from the military. There is no immigration benefit whatsoever for serving in our military, by the way. So Paul, 17 or 18 at the time, had no reason to doubt this person and enlisted again as a student here legally as a farmhand doing an exchange. So to serve in our military, you probably know you have to either be a US citizen or a permanent resident, a green card holder. Paul was neither of those, and he served, he enlisted in March, and the Persian Gulf conflict was still going on, but he was not shipped until November. And the reason he was not shipped was they had trouble getting his foreign passport. So they definitely knew he was not a US citizen. He was shipped in November. He served honorably for several years and then was discharged and honorably, and believed the recruiter's promise of citizenship. In the meantime, he lived and worked as a US citizen. He registered to vote and voted several times. His wife is a US citizen, is a few US citizen children, one of whom is in the reserves, and had been using his DD-214, his discharge document, for VA benefits and to get his driver license. And for those of you who have relatively recently renewed your Florida driver license, you'll notice the yellow star in the upper right corner of your license, which shows that you presented real ID compliant documents to get that license. So one of the requirements of real ID is to prove your lawful presence in the United States. So Mr. Canton had been able to get his license for years and years using his DD-214 until Florida became a real ID compliant state. And then in 2019, he went to the DMV to renew, and the officer said, DD-214, all it shows is that you served in the military and is not evidence of citizenship, which is indeed correct. So Paul Canton got the surprise of his lifetime and realized that he had been undocumented since his exchange student status ended 30 years prior. And he was told to call immigration and apply for citizenship. Well, a prerequisite of citizenship is permanent residency or a green card, which, as I said, he did not have. So he filed for citizenship pro se, and he was denied. And then he came to find me through the American Legion, and I filed for him. And he had his interview in June of last year, and he was denied his citizenship. I had applied under an exception. So there's an exception for having the green card first if you served during a designated period of hostility, like Vietnam, World War II, Enduring Freedom. So that was the basis of our filing last year. So he was denied, and the reason for the denial was twofold. One, that he was a person of poor moral character for having voted, and two, that he did not serve during a designated period of hostility. So I refiled, and I'm at that interview as you're watching this today. And the basis of the refiling was, one, I pointed out to immigration that the poor moral character requirement is for 1 year prior to application, number one, and he hadn't voted in over a year prior to application. But number two, it does not even apply to veterans. But secondly, that this argument that he did not serve during a period of designated hostility was inaccurate, because although he did not actively serve, when he enlisted in March, he was ready reserve and was eligible to serve immediately. He did not have to be shipped to serve, and that is enough, according to immigration law, to have allowed him to be considered to have served during a designated period of hostility. So hopefully, if I get out in time and I'm able to take your calls and we can talk, I'll tell you that I was successful. If I was not successful, we will be litigating and I will be seeking EAJA fees for Paul Canton. I do want you to know that his case is not unusual. I have several cases like his, and this is my little PSA before we end for the day. There are over 500,000 foreign-born veterans alive in this country. Many of them do not realize that they are not citizens, and it will take something like hearing about Paul's case to realize that. So if you know of a foreign-born veteran who does not have a certificate of citizenship or a certificate of naturalization or a US passport or well, you wouldn't have a US birth certificate, but I suppose you could if you were adopted and readopted here, then that person is probably undocumented, and they may need to seek assistance from the American Legion or some other entity that helps veterans. The problem there may be if they did not serve during a designated period of hostility, then they may not be eligible, especially if they have some kind of criminal history or voting history that would preclude them from otherwise gaining permanent residency. So this is a big issue that I'm trying to inform people about, and I would be happy to answer any of your questions regarding veterans in particular. So again, my cell, 850-544-9970. My email is elizabeth@rambana.com. My husband and law partner, Neil Rambana, does the deportation defense, the crimmigration. So if you have questions about a plea, he would be a good person to talk to. His email is neil@rambana.com. I am sorry I'm not with you today, but I appreciate your time, and I thank you for having me. I look forward to getting together with everybody in the future. Thanks. Bye-bye.